So, good afternoon to one and all present here. I, Adya Desai, heartily welcome you to the final day and the final session of the week-long conference on law and economic theories and applications organized by GNLU Center for Law and Economics. So, today our resource person is Professor Ram Singh, sir. And as you already have interacted with him and as you have already learned a lot about law and economics from him, I hope that the concluding session conducted by Professor Ram Singh sir will be a rather memorable one, and it will illuminate and kindle an interest of law and economics in all of the participants. So now I'll request Ram Singh sir to begin with today's final session.
Thank you, Ad. Thank you for your introductory words. So I have slides. Let me start by mechanics of contracts. Okay. I will need you to confirm if you can hear me right and if you see the slides.
Yes to both.
Okay, thanks. So, dear all, let me welcome you to my lecture this afternoon. It is the last day of this workshop. I'm sure you have had very interesting and learning experience as a participant in this workshop. So today we are going to have a kind of marathon session. It will run in 3 hours. If you would like, we can run, 2 half marathons and complete the marathon. So what I'm suggesting is that we at 20 minutes past 4 o'clock, we can have 15 minutes break. You can, at your respective places, you can get yourself water, tea, coffee, or any other energy drink, or just fresh oxygen. So that, we grasp, I say, more meaningful things and you grasp more of what we will discuss in the second half of the session today. So I hope that's okay. So let me take the liberty and decide that we will break around 20 minutes past 4 o'clock for 15 minutes. Today's session is going to be on contracts, economic analysis of contract law, or law and economics of contracts. That's the topic we are going to discuss today. And since we have some time today, I would like to encourage you to ask questions. So, you can, at any point you feel like asking for clarificatory question or question that you want to raise, do raise the question. You can ask question directly or type your question in chat box, and maybe Adya can keep track of questions that will be raised in the chat box. So let's get started with the contracts. We can start by asking very basic question. Why do people enter into contracts? So before we address this question, we can even ask more elemental question. What do we mean by a contract? A contract is a promise, but not all promises are contracts. So a contract is a particular kind of promise. The word contract has legal connotation, but essentially for the purpose of discussion today, at least for the as a starting point, we can think of a contract that serves that is essentially a promise between two parties. The major distinction, technical distinction between a promise and a contract is actually twofold. One is that a promise can be one-sided. You can promise something to do for somebody without expecting anything in return, without having consideration for your promise. But the legal contracts, what promises that qualify as a contract have generally bidirectionality. The promise in one form or the other runs in both the direction. So a supplier promises to supply a good or service in future, and you promise to make a payment either upfront or in future. So one key aspect is that the contract is a two-sided promise. So one person makes promise, but other person also makes promise to do something. One may supply goods or services, other will promise payment. But the steps taken to fulfill promises, that order can change. For example, you can make payment upfront and then seller promises to supply in future. At times, suppliers can supply upfront now and you promise to pay in future. Or you could both promise for future, the supplier will supply 6 months from now and you will make payment at the time of good gets supplied. So that the timing can change, but there is a both sides make some kind of promise. The other technical difference between a promise and contract would be that the contracts are those promises that are legally enforceable, meaning thereby if one of the parties to a promise refuse to fulfill terms of promise, then the party that has been hurt can take the other side to a court and ask for enforcement of the contract. The moment you think of enforcing a promise, enforcing a contract, you of course have to produce evidence that there was such an agreement, and to make sure that you will be able to produce evidence if needed, then promises generally get written as a contract document. So as a result, you have to pen down your promise on paper using ink. Then the standard, what is called bargaining theory of contract, it talks about one key feature, which is that both sides have to offer something. So both sides should gain. So a contract is a promise in which both sides gain something and both sides sacrifice something. For example, the seller sacrifices goods but receives a payment. And if you are a buyer, then you sacrifice money, but you get goods or services. So both sides should gain, both sides should make some sacrifices. So these are the technicalities of a contract, a promise that qualifies as a legal contract, legally enforceable promise. Let's briefly discuss why people enter into contract. So we need goods and services of large variety, but we don't need to sign contract for everything that we need. For example, you buy many goods and services on the market like bread, fruits, furniture, standard furniture items, etc. There are many goods we buy on the market. We simply go to the market, there is a seller, and good and money exchange hands, and there's no need to make any promise of any kind. Thereby the need for contract does not arise. However, in some situations need for contract arises. For example, universities, colleges, and schools, they have teachers on employment contract. So we can make this distinction between contractual employees, contractual teachers, and regular teachers. Teachers who call themselves as regular teacher or permanent teachers, they also sign some contract with their employer. So every type of employment in formal sector will have some contract between employer and employee. The terms of the contract differ. Then so buyers and sellers typically, for example, a power producer, a power plant, a steel plant, they will typically sign contract to secure supply of their inputs. Inputs could be coal, input could be iron ore. So in businesses, so we we see the entities that are in business of production, they sign contract to secure supplies of their inputs. Then on other occasions, we need to buy not standard item, but we need to buy customized items, goods or services that fulfill our specific need. For example, if you think of cars, I don't know what the market situation today is, but if you are thinking of standard Maruti white color car, then you don't need to sign a contract beforehand. You can go to a dealer who has franchise with Maruti, and you can simply go make a payment and get a vehicle. And of course, in the transaction, you have to do paperwork, but the promises don't need to be made. On the other hand, if you order a car with specific features or specific colors, then you will end up entering into some kind of understanding agreement contract with the dealer, that you will make some advance payment and dealer promises to supply the vehicle at a specified date in future. So this suggests that whenever there's a need to buy specific to fulfill your specific need, or when you need a good or service that meets your requirement but otherwise is not standard, other people may not be equally interested in that good or services, then you need to enter into a contract. We enter into contract with insurance companies because we want to hedge ourselves against risk that can arise. The insurance could be medical insurance, it could be motor vehicle insurance, it could be insurance against theft or fire, and that depends. But the idea is that we sign insurance contract, because something can happen in future and we want to deal with something that can happen to us in future. We want to deal with that today itself, and we enter in contract. Similarly, we sign debt contracts if we borrow from a bank or from any other lender, institutional, non-institutional lenders. Generally, borrowers and lenders, they sign contracts. In all such situations, wherever you sign contract, you will find that both parties make promise, as we have already seen. But the other key feature would be that one of the promises, as I said, both parties make some sacrifice and gain, and both parties make some promise in one form or the other. But one of the parties can fulfill its contract in future. That is why contract needs to be signed. If both parties could meet their obligations, their promise simultaneously, today there'll be no need to sign a contract. We don't need to sign a contract with the grocery shop, because our obligations, you want bread or sugar, your obligation is to pay for it, and the shopkeeper's obligation is to provide the demanded good. Both these obligations, both these promises can be executed simultaneously today. As a result, there's no need for contract. So contract, you will find typically or almost always will entail a situation where one of the parties can fulfill its promise, its obligation, contractual obligation only in future. It can't do so today. That's why there's a contract. So my slides have disappeared. Do you see slides? I didn't unshare them, but somehow they disappeared. I'm sharing them again. Can you see the slides? So we have discussed these issues, why people enter into contracts. We have different motivations. Different people, different sets of individuals have different motivation to enter into contract. Our needs differ, and some of these needs, demands can be fulfilled, can be met in future. That's why there has to be a contract. Any question at this point? If you don't have question, then I have questions for you. These are easy to answer questions. This is just to get the discussion going. So in all the examples we have considered during last 5 minutes, do you think both parties benefit from a deal, a promise, or a contract? Answer is yes. So if a contract is voluntary, then both parties will necessarily gain from it, or at least they think that they will gain from it. This leads to the next question. Does it mean that an agreement or a contract, if executed, will result in Pareto superior outcome? You may remember discussion from last time. A Pareto superior outcome is an outcome where all the parties involved, they benefit. So a typical market exchange, in a typical market exchange, goods and money change hands, and both parties gain in the process. Therefore, in a typical market exchange, since both parties gain, the market exchange leads to Pareto superior outcome. So all voluntary exchanges, they make all the parties involved better off. Therefore, the voluntary market exchanges are Pareto improving. Can we make that such a claim, a similar claim about a contract? Well, it depends. So in terms of ex ante sense, in ex ante sense, the Pareto improvement is expected. Think of any contractual situation, be it insurance contract, be it contract to buy a particular piece of furniture in future, or red color car, or any other contract that you sign in. You enter in the contract because you believe that what you will get in return is worth more than what you pay. Your gains from contracts are going to be greater than what you have to sacrifice according to terms of the contract. If you feel so, only then you will voluntarily enter into a contract. Therefore, when you sign the contract, you feel better. You feel that you believe that you will end up better. The other side of the contract has similar beliefs. So both sides believe that the contract is going to be beneficial to them. So in ex ante sense, contracts are Pareto improving. In ex post sense, we may end up with different scenarios. So therefore, we have to make a distinction. For example, if you buy health insurance, you buy motor vehicle insurance, you pay premium, and if it turns out that you remain fit, you didn't your vehicle didn't suffer from any damage because there was no accident, luckily, then you may feel that, look, I paid premium for nothing. On the other hand, if by chance you end up in an accident, and though in that case what you find is that even though you had paid premium of few thousand, but the compensation you get in terms of the repair cost, reimbursed repair cost for your vehicle could be in lakhs, and you may say, oh my God, thank God I had this insurance. So you may feel very good that it was a great idea to enter into a contract. But from the insurance company viewpoint, the argument has to be put on its head. When you end up happy in a contract, the insurance company would have to pay. So it's not a good thing for them. On the other hand, if you remain healthy, no accident, what year after year, you have kept on paying insurance, and you have kept on paying insurance premium, and company kept on collecting it, and didn't have to reimburse you any expenses. In that kind of situations, those kind of situations are good for company, but you may ex post feel, oh God, there was not much point in buying this insurance. So the point is that in some situations, uh, the contractual situation ex ante, when you sign the contract, can be very different from the ex post situations that parties, contracting parties, find themselves into. So we have to make that, you have to keep that distinction in mind. So, however, as long as at the time of writing the contract, both parties expect, hope to gain from the contract, and that makes a case for legal enforcement of agreements or contracts. So since we want a contract, we feel that contract is good for me, other side also feels so, then both of us want contracts to be enforceable. Ex post again, one of the parties may not be interested in, may actually start wishing that, let there be no enforcement of the contract. So that will depend on situation. We will consider several situations. So to sum up the discussion so far, a contract is a promise, a legally enforceable promise or agreement. And since it is a legally enforceable agreement or promise, it means that if one of the parties, one of the parties to an agreement, they renege on the promise, then the other party or parties can take them to a court of law and insist on compensation or on specific performance. We will discuss these remedies. So any questions? If there are questions, so this will be a good time to take some questions. Okay, very good. I hope you are around. Okay, so let's take an example to see what purpose contract can serve. We will consider example of a debt contract. So specifically, we have two individuals. So this issue arises whenever you think of startups or unicorns or any new venture. And this issue arises whether you think of illiterate poor Indians in villages, or you think of um, engineers who have gone to IITs, IIMs, and have their ideas and want to launch a company or firms. So the example we are going to consider now is applicable in a wide variety of settings. So we consider two individuals. One is an investor, has money, and other is an entrepreneur. Entrepreneur is denoted by E. Entrepreneur has an idea, has a project in mind, but does not have money. But the investor, I will denote investor, has money, but does not have ideas of her own or his own. If E and I, entrepreneur and investor, come together, then they can launch some project, some activity that can be potentially beneficial for both. Entrepreneur, as I said, entrepreneur could be an illiterate farmer thinking of a particular way of farming or starting some agro-based activity, or entrepreneur could be highly qualified management or engineering graduate. Investor, on the other hand, could be a bank or a venture capitalist or any other lender. So these two sides come together. If they cooperate with each other, then both can end up better off. But let's see whether they can come together. Now, entrepreneur has an idea, wants to launch a project, and the project will cost. We are taking simple example. Suppose the project or the idea entrepreneur has in mind requires its execution. Its execution requires 1 million rupees, dollars, doesn't matter. And if this project is completed successfully, it will generate an income of 2 million. But this process will take time. So let's say 6 months or 1 year or 6 years. The point is that if E and I work together, they can generate net profit of 1 million, because the idea or the project cost is going to be 1 million, but income is going to be 2 million. So net profit is going to be 1 million. They can split the profit between two of them. The entrepreneur is interested in executing the idea but does not have money, and therefore has approached IE investor that please invest in my project. That's what startups do. That's what farmers do when they go to cooperative banks or NABARD or commercial banks. Now, the two have to take a call. The entrepreneur says that if you invest 1 million, after 6 months, I will pay you back 1.5 million, meaning thereby the profit of 500,000 is that entrepreneur is promising to the lender investor. And entrepreneur also hopes to end up gaining 500,000. Now, in such a situation, the investor has to decide whether to lend or invest in the project or not. If investor does not invest, does not buy the story put out by the entrepreneur, then that's end of the game. On the other hand, if investor puts in money in the project, hoping that entrepreneur will execute the project as he has promised, then in that situation, once investor has supplied the money, then it's turn of the entrepreneur to decide whether to use that money as promised or misappropriate that money and basically run away that money. So this is the situation. This is a simple situation, but this situation arises in many contexts. We will think of two situations from legal viewpoint. One situation we consider is that, if these two individuals, they enter into some kind of agreement, then there's no legal protection for such an agreement. We are assuming it's a hypothetical situation. We are considering it to make a point. The other situation 2, we will consider is that the agreement signed between two of them is legally enforceable. So we will see that the two situations will lead to very different outcomes. Under first situation, what is the meaning of situation 1? That the situation 1 is there is no legal protection of an agreement between entrepreneur and investor. It essentially means that if entrepreneur runs away with money, then no court will come to rescue to help the investor. So in real world, such situations can arise if there is no contract law, or even if there is a contract law, then at times it's difficult to get the contract enforced. And such a situation like 1 can arise. But we are considering situation 1 as a hypothetical situation to make a point. So let us see what outcome will arise in under situation 1. Under situation 1, remember, under situation 1, there is no legal remedy available to the investor. Investor, it means that entrepreneur, the borrower, if the borrower runs away with money, nobody is going to do anything about it. In that situation, let me spend half a minute to tell you how to read this table here. So E, as before, stands for entrepreneur. I for investor. Investor has two alternatives, two options available. Option 1, action 1 is to lend or invest in the project. Other is do not lend. So these are the choices available to the investor, IE. So I have listed the choices, these actions, these options here. E also has two options. For any decision taken by investor, entrepreneur, borrower has to decide whether to cooperate, that means that put the money in the project as promised, make money and repay the principal with interest, or other choice available to the borrower entrepreneur is to misappropriate, run away with the money. Now, with these clarifications, the final clarification is that there are two terms in brackets. The first term shows gain for IE, investor. The second term shows gain for entrepreneur. Now let's start from here. If the investor does not invest, does not lend, then both sides get zero. I gets nothing because I earns no interest, and E gets nothing because without money, E can't launch her project. So the decision of E is actually is not of any consequence if I does not lend. So basically, the decision of E in that case is only hypothetical decisions: cooperate, non-cooperation. These are only hypothetical situations. However, if investor bank decides to invest in the project, which is to say lend the money to entrepreneur, then entrepreneur is looking at a real choice of to cooperating, meaning thereby fulfilling terms of the promise or the debt contract, or run away with the money. Running away with the money we call appropriation, or appropriate action decision by E. If E appropriates, run away with money, what will be the outcome? What are the gains for the investor? Well, investor has lost its 1 million. So as a result, minus 1 is minus 1 million is what 1 million is what the investor loses, is going to lose. Therefore, we have put minus sign here. What is that E, entrepreneur, borrower who has run away with money will get? Well, she has got 1 million. So entrepreneur ends up with 1 million and investor ends up losing 1 million. So this situation is depicted. This situation arises when investor lends in or invest and entrepreneur borrower ends up appropriating, running away with the money. However, if entrepreneur cooperates, then what is that they will end up with? Remember, the project is going to cost 1 million. It's worth 2 million project. So net profit is going to be 1 million. And suppose they divide the profit half-half, meaning thereby half a million, 5 lakhs is what the bank will earn by way of interest, and 5 lakhs, half a million is what entrepreneur will end up earning. So their payoffs in this case are going to be half-half. So any clarificatory questions on how to read these boxes or this table? Any questions? If not, then question for you is, what will be the decision of investor? Would investor want to make investment in such a project under such a situation? I want somebody to answer the question. Some other participant, there are two answers who have answered. Okay, Dhruv Ashish says no. Okay, all right. Then there is a question before that. Bond is also a contract. Sure, bond is also a contract, but specifically on the point, Dhruv says that investor will not invest. So that's a correct answer. Why investor would not want to invest? Well, investor reasons will reckon that if I invest, if you are investor, then you will reason that if you invest, then the other side would find it profitable to run away with the money. Why? Because running away with the money means that the other side entrepreneur will get 1 million. But if he cooperates with you, he will get only 500,000. So in such a situation, running away with the money is a better option for entrepreneurs. It's a better option for him. He will go for it, but you are no fool. So you know that this is what he is going to do. And knowing this, then you would not want to invest at all, because if you invest, you know that you are going to end up with a loss of 1 million. So why should you do that? You will decide not to lend. So the outcome is going to be no lending by the investors. So this is going to be the outcome. That's going to be the equilibrium outcome. In equilibrium, you will not invest. And now, I'm not saying that this outcome, every borrower is going to behave like this. That's not the point. Point is that some borrowers will be tempted to behave like this. You know, the problem of NPAs, non-performing assets, is a serious problem. This is an evidence that many borrowers do not want to pay. So commercial banks, cooperative banks are facing difficulty in recovering the loans they have issued. That is an evidence that at least some, or maybe many borrowers, entrepreneurs do not want to return the money, cannot or do not want to return the money. And remember, NPA problems faced by commercial banks, cooperative banks, it is in presence of contractual protection. Even then there's a problem. Assume that if there is no legal remedy available to lender banks, what will be the situation? Point is that in many situations, many borrowers would want to run away with the money. Not every time, of course. You know, if borrower and lenders, they have social ties, they know each other socially, they have in presence of social ties, people would want to fulfill their promise, even if there is no court around. Or some people are innately, intrinsically honest people. They want to fulfill their promises. So it's not that every single entrepreneur borrower is going to run away with money, but many would. This is how you should look at the situation. Let's now focus at the situation assuming that entrepreneur, or let's now consider the situation involving entrepreneur borrowers who would want to run away with the money, who have no moral compunction when it comes to running away with the money. What can law do? That's the question we are asking. Suppose the legal situation is that the borrower has to fulfill terms of the promise. Agreement between two of them is that what is the agreement between borrower and lender? In our example, the agreement is that lender will lend 1 million today and will get back 1.5 million after 6 months, once the project has been executed. Why will lender get 1.5 million? Well, lender wants to get his principal amount back, which is 1 million, and 50% of the profit. Profit is 1 million, so 50% is 500,000. So that's why the lender would want 1.5 million back. That's the agreement. If there's a court of law that can enforce this agreement, then let us see how the situation changes. Same situation, but now the outcome will be very different. As before, if the lender does not lend, then there's nothing that entrepreneur can do. Entrepreneur can't do anything, can't launch the project on her own. So both sides end up with zero payoffs or zero gains. Now, but if the lender invests, puts money in the project, and the entrepreneur cooperates, then again both parties will end up with a net gain of 500,000. 0.5 million is what they will end up with. What will happen if an entrepreneur wants to run away with money? Well, that option has been foreclosed by assumption that there's a law. The lender can go to court, and court will force the entrepreneur to pay back the entire principal and 500,000 more, because that was the agreement. meaning thereby that if the entrepreneur decides to default now, doesn't invest money in the project, the lender will still make profit of 500,000. But now entrepreneur will end up with a loss of 500,000. Why? Entrepreneur received 1 million from bank, investor bank, so that 1 million has to be returned. Moreover, entrepreneur did not, since the entrepreneur did not invest in the project, so entrepreneur will have to pay 500,000 out of her pocket or borrow it from somebody and then return the money to return the total amount of 1.5 million to the bank, to the lender bank. Net gains for the bank are going to be 500,000, and entrepreneur will end up losing 500,000 in such a situation. Now you can see, now the lender bank doesn't have to fear that the borrower will run away with the money, because if the lender bank lends, then entrepreneur has two choices: to invest the money appropriately or misappropriate it. Misappropriation means net loss of 500,000 for the entrepreneur, and cooperation means net gain of 500,000 for the entrepreneur. So entrepreneur in her own interest would want to cooperate, would want to use money carefully. Knowing this, lender bank will have no hesitation in lending the money. So now earlier on the outcome was do not lend. Now that outcome has been changed by contract law to a situation where lender wants to lend and borrower wants to cooperate. Both parties becoming better off in the process. So in such a situation, the lender would want to make advance investment in the project. Outcome is going to be good for both the sides. This outcome, when there is no law, then this outcome is not good for any side, because they remain what they are. There were potential gains. They could work together, earn money for themselves. They fail to do so in the absence of contract law. But in the presence of contract law, then both sides have incentives to work together to produce, to generate, to engage in production of goods or services. In the process, they benefit and society also benefits. So that is the main idea behind contract law. Any questions? Ask some questions unless you find it too simple. How many of you are familiar with game theory? Among the participants, are there people who know game theory? Okay, all right. So then next question we want to see is, can we have different types of contract law and still get the efficient outcome? Or we need a special kind of contract law to achieve efficiency? That's the issue we will consider. That's the question we are going to consider, take up for discussion. We will stay put with the same example. In our example, lender bank lends 1 million and borrower entrepreneur agrees to repay the entire principal amount plus 500,000 by way of interest. We will assume that there is a contract law, meaning thereby if these two parties they sign a debt contract, then bank can go to court, to a court of law, and demands enforcement of contract if entrepreneur wants to run away. So there's a court, but court has to apply some rules, some law. We consider two of several possible legal positions. One legal position we call rule 1. Under rule 1, we say that if E entrepreneur does not take up the project, wants to run away with the money, then he has to return the money and also pay additional $500,000 as a compensation. Okay? So this is one legal situation. We call this legal situation as a rule 1. Under rule 2, if the borrower wants to run away with the money, a court is going to direct him and force him to return the money back to the investor's bank. But there's no additional payment penalty imposed. So all under rule 2, a court is going to say that you got 1 million from lender bank, return that money. But court is not going to say that you also had promised to pay interest. So suppose court is not going to insist on payment of promised interest amount. So these two legal rules are different in terms of obligation of the entrepreneur if entrepreneur reneges on the contract. Okay. We want to know whether these rules will lead to different outcomes or not. Also, we want to know whether both rules will lead to efficient outcome or only one of the rules will lead to efficient outcome. By the way, we have just concluded our previous two slides were nothing but application of rule 1. Under rule 1, we discussed that under rule 1, investor bank would want to invest and borrower entrepreneur would want to cooperate, behave cooperatively, invest in the project, earn profit and share that profits with the bank. So we already have seen outcome under rule 1. We saw that rule 1 leads to a Pareto improving situation. We want to know whether rule 2 can also achieve similar results. If rule 2 can also achieve similar outcome, that would mean that the efficiency can be achieved by different possible rules. Law does not have to be changed in a unique way to promote efficiency. Law can have some kind of diversity across states or across countries, and still they can promote efficiency, or different legal rules can promote similar kind of efficiency. That would be the message if rule 2 also turns out to be efficient. If rule 2 turns out to be inefficient, then we will have to say that rule 2 does not promote efficiency. If we want to promote efficiency, then we cannot entertain rule 2. Rule 2 will be incompatible with efficiency if rule 2 fails to lead to an efficient outcome. That's what we want to say. Under first rule, we have already seen that under first rule, payoffs are going to be as discussed here. So I'm not going to repeat this argument. You, on the other hand, are welcome to ask any clarificatory question. I will go to second rule straight away. Under second rule, again, the actions or choices available to the parties do not change because of law. The actions available to you and me as citizens in this country, they do not depend on what law of land is, what our constitution is, what Supreme Court has decided has no bearing on the action sets, choices of actions available to us. What law does is it declares some actions, some choices of ours as legal and other choices as illegal. Some choices are declared as criminal choices. But the choices do not depend on the law. That is one point I want to make. So it means that whether we have a contract law that applies rule 1 or we have a contract law that applies rule 2, it's not going to change the choices available to the two parties. Choices available to the lender bank are lend or do not lend. And choices available to entrepreneur, borrower, entrepreneurs are simply to cooperate as in the contract, as in the promise, or to run away with the money. Now, if as before, if the lender does not lend, then there's nothing. Two sides, they will remain at zero, regardless of what entrepreneur wants to do. What entrepreneur wants to do has no bearing now because lender has not put in the money in the project. But if the lender has put in money and then cooperate, if the entrepreneur cooperates, again the payoffs would be same as before. Each party will end up with a net profit of $500,000. Question now is, if entrepreneur wants to run away with the money and rule is 2, under rule 2, a court is going to force the entrepreneur who wants to renege on the debt contract, that entrepreneur will be forced by court to return the borrowed amount. The borrowed amount was 1 million. That amount will be returned back to the bank. So what is that bank gets in this situation? Bank put in 1 crore, bank got its 1 crore back. So bank ends up with 0. What does entrepreneur ends up with? Entrepreneur also ends up with 0 because she received 1 million from bank but was forced to return that 1 million back to the bank. So entrepreneur also ends up with 0 if she does not cooperate, if she wants to run away with the money. However, if entrepreneur cooperates with the bank, then they can earn $500,000 each. You can see that in this situation, if the bank is going to invest, then entrepreneur wants to cooperate. Here, this is rule 2. Remember, this is rule 2, this is rule 1. If you compare, if I ask you to spot the difference between what you see here and what you see here, you will see that only difference arises here, here, and here. Otherwise, everywhere situation is identical. The payoffs, two parties end up with different gains if entrepreneur does not cooperate. If entrepreneur wants to run away with the money, in that case, two rules will lead to different payoffs for the two parties. However, even under rule 2, entrepreneur wants to cooperate because she can earn $500,000 by cooperating, by complying with the terms of the agreement, by complying with terms of the debt contract. So the point, therefore, so the outcome is going to be a cooperation. The entrepreneur wants to cooperate. Knowing that entrepreneur wants to cooperate, bank would want to invest because bank also can earn interest from willing borrowers who would be cooperating. So these two rules are different, but they lead to same outcome. Outcome is that under both the rules, bank would want to lend and borrower would want to cooperate, use the money prudently. This goes to show that rules can be different and still they can lead to the same outcome. The same outcome can be efficient outcome. That's the point. So both rules lead to efficient outcome, Pareto improving outcome. Remember, if there is no rule at all, then both parties will end up with 0 payoffs. But rule 1 takes them from this situation to this situation where they earn $500,000 each. Rule 2 also leads to similar Pareto improving outcome from 0 to $500,000 each. This is a simple example, but this is the main idea that is applicable in many contractual situations. You can go back to insurance contracts, debt contracts, you can go back to any contract over for supply of goods and services. This is the basic idea. In the absence of contract law, the person who has received payment or goods may want to renege on their promise, but the contract law can force them to cooperate and lead to, and contract law lead to Pareto improving outcomes. So there are questions I can say. Yes, please ask your questions.
I don't know, with regard to bank, it will not happen that some may be defaulted and some may lead to insolvency and then like that. Like some project maybe generally default and they are going into the bankruptcy, maybe later on liquidation. Then
Right. So, first of all, if there's a proceeding of bankruptcy against a defaulter borrower, that essentially means that contract law is at work. That's the first inference we should derive. Now, what could be the difference between a situation where borrower borrowed and repaid the principal and also the promised interest, versus a situation where borrower, entrepreneur borrowed, but the bankruptcy proceedings had to be initiated against her? What is the difference between the two? The difference is essentially rule 1 and rule 2 type of difference. Under first situation where the entrepreneur borrowed and repaid, then this is basically the kind of situation. Under bankruptcy, the bank, if the borrower does not cooperate, then borrower may not get interest back, may get only the principal amount back. In some cases, may not get even the principal amount back, may get only the principal amount back, only a part of the principal amount back. But the major point here is that if bankruptcy, think of a situation where hypothetically bankruptcy proceedings will give you back only your principal amount and not interest. This example shows that even that kind of bankruptcy can make people behave cooperatively, act cooperatively. So bankruptcy proceedings, to the extent they retrieve most of the principal amount, will generate incentives where future entrepreneurs would want to cooperate with banks and not run away. However, the situation will change if the banks are going to lose part of their principal also. That happens in some cases that are being adjudicated under IBC. So that would be those situations where banks cannot reclaim even the principal amount will lead to inefficient outcomes. But the major point here is that just because there's a bankruptcy proceeding, it does not mean that the law is inefficient. It can still generate efficient incentives. The crucial point is whether under bankruptcy, banks can retrieve the entire principal amount or not. That would be the key to efficiency of bankruptcy. The other thing to note about any law, be it contract law, be it bankruptcy proceedings or tort proceedings, is that if a contract has been violated, it has been violated. If a tort has been committed, it has been committed. If a crime has been committed, it has been committed. Law can't do much about the outcome of that situation. It can only redistribute, it can either provide retribution or some compensation. But the accident has happened, that situation cannot be changed. The contract has been reneged, that situation cannot be changed by the law. The way law serves efficiency enhancing purpose is by creating incentives for the future. It's for the future that efficiency of any law that comes into the picture. And the future, the future depends on how courts or insolvency courts, they resolve today's dispute. Because how today's disputes are being resolved, that will create signals about future. If today borrowers can run away with money with impunity, tomorrow's borrowers will also think that we can also run away with money. But if today's defaulters are being penalized, are forced to repay the principal or principal along with interest, then tomorrow's borrowers will also be careful. They would know that if I renege, if I default, then I'm going to be forced into compensating my lenders. Then so you can now clearly see, depending on what happens today, depending on what courts do today, will have serious consequences for tomorrow. Efficiency will be realized tomorrow. Efficiency or inefficiency, it will materialize tomorrow. So the efficiency is always forward-looking perspective. Actual adjudication is a little backward-looking. I'm not saying backward in literal sense. It's not regressive. I'm saying backward in the sense that it is counterfactual inquiry that happens in adjudication. But the efficiency, the idea of efficiency is forward-looking. It is, we ask a question. If court rules make decisions like this, what will be future actions taken by citizens or subjects of the law? All right. So we have seen that now, to sum up the discussion, we have seen that presence of law can change situation from no gains situation to both party gaining situation, meaning thereby a law can lead to Pareto improvement. Pareto improving exchanges can be facilitated by law, and a law doesn't have to, efficient law doesn't have to be unique. Law can be of different shades, different types, and still they can be efficient in some cases at least. That's the point.
Professor, Professor,
yes,
with regard to
yes,
Rule 1 and Rule 2,
yes.
do the efficiency outcomes remain the same after we factor in the enforcement cost, the time cost?
No, we have not factored in the cost of enforcement. If we assume that cost of enforcements are same and small, if we assume that, look, court doesn't have to put in added effort in enforcement of Rule 1 versus Rule 2, then our conclusion will also remain the same. However, if courts have to put in added effort to first find out the principal amount and then in finding out the interest amount, then these conclusions can change. This issue arises more importantly in a tort setting, not so much in contractual setting, because in our example, we can, a debt contract will mention the principal amount that the bank has lent to the borrower. It will also mention the debt contracts we signed with our bank. It also mentions the interest rate that will be paid, and also payment schedule also. So court can look at one document and get all the information from there, meaning thereby looking at one document, court can apply Rule 1 and also apply Rule 2 at same cost, and therefore our conclusions will not change even if we bring in the cost of enforcement. But in some cases, the conclusion can change because if courts have to put in a lot of efforts in enforcement, and if different rules require different kind of enforcement efforts by the courts, then those costs can change our conclusions. So for example, between rule of negligence in a tort setting versus strict liability, a strict liability rule is easier to enforce. Enforcement costs are lower for strict liability kind of rule versus negligence kind of rule. Under strict liability, a court just has to make sure that the injurer, alleged injurer, has inflicted loss on alleged victim. Court doesn't have to check whether alleged injurer was negligent or not. But under negligence rule, they also have to find out whether alleged injurer was actual injurer in fact, and whether the injurer was negligent or not. I think somebody is trying to speak. Is that the case?
No, sir, my mic is on only.
Okay.
So just one follow-up question. So has this been tested? I mean, do we have empirical results of this? Because from a future signaling point of view, a comparative sense that when there is a penalty, then from a future signaling sense of view, out of X number of contracts, how many really, what the outcomes were. Because from a signaling sense, just normally speaking, it would seem that penalties, as in case of IBC, would create maybe stronger incentives. Could it be like that?
Yes, you are right. It is intuitive to think that penalties will create added stronger incentive to behave responsibly. That is true. But we have to be careful. If we, so why do we need penalties in any situation, be it a contractual situation, be it a tort situation, or a property dispute? We need penalty only when there's a possibility that the offender may go scot-free. When we find that probability of enforcement is less than perfect, then penalties have important role to play. Under insolvency and bankruptcy, you are right that provision of penalty will have greater bite. But that is true. But we should also keep in mind that under insolvency and bankruptcy kind of situations, many a times defaulter borrowers go scot-free because somehow they siphon off not only money but also the assets of their companies and firms. As a result, they become judgment proof. The terms of the contract cannot be enforced by court because the assets of the companies are not so many to make sure that banks get at least the principal amount back. In such a situation, you want to send signal that look, at times you may get scot-free and without any consequence, but other times if you get caught, you will have to repay not only the principal amount but also penalty. The role of penalty arises when enforcement probability of punishing the offender is less than 1. Then penalties provide added needed bite, needed force to the law. In a hypothetical situation of perfect enforcement, there is no need for penalties. Penalties only redistribute.
All right, sir. Thank you.
The second rule means both are cooperating. Is it like that?
Under, like say in this example, in second rule, there is no penalty, yet both cooperate. So these two rules also go to show that that if the enforcement is correct, is complete, perfect, then penalties are not needed. In real world, enforcement is not perfect, therefore penalties are needed. Remember, about interesting thing about penalties is there something very interesting about penalties. People who pay penalties are not necessarily the ones who are the only wrong doers. Who are, it's not that only the offender, all offenders pay penalty. All offenders, if you can make all offenders pay something, then penalties might not be needed. Penalties are needed whether it's a hit and run case in case of accidents or jumping off or driving dangerously. Penalties are needed because some people manage to escape force of the law. So to create examples again, those who get caught, you penalize them with much severe penalty. Again, the idea is forward looking. So if there's a penalty, then people will think that, at times I may run away without any legal obligations, but if I get caught, then I will have to meet not only the cost, but also the penalty. And that makes people fall in line with the law. Hitesh, you have other question?
No, sir, I was just thinking that in this setting, in this environment,
Yes.
I don't know, but just in practical sense, if we go with the practical setting, uh, like this may look more hypothetical, where
Which
maybe
one?
both the cases, like first cases and second cases, because
Both.
yes, both, because we are not factoring the repeated game theory, because and generally I feel the contract and subcontract market, which are mutually interdependent market, and they are not happening from one time, they are from long change, they are happening. Even one small betrayed, one small
I think I got your I think I got your point. You see, if you remember, I mentioned that I'm not saying that every borrower would want to run away with the money. Not every promiser wants to renege. It could be that they are social ties, or they could be in repeated transactions. They could be playing what they call repeated games. In those situations, even in the absence of contract law, people can behave cooperatively, they can cooperate. Point here is that the point which I thought I had emphasized, but I would like to emphasize it again, is not, we do not need contract law or liability law or accident law, traffic rules. We do not need them because everybody is going to be an offender. Point is that some people will be offenders. Some people would want to run away with money. Even if there's a possibility of repeated transactions, some people want to run away with money for different reasons. Some people would never run away with money. They will fulfill their verbal promise. Forget about, not only they will fulfill their written promises, they give you a word and they will go extra length to fulfill what they promised you. But majority of people at one opportunity or the other will renege, and contract law takes care of that set of people. So the mechanisms like, social ties, you and I come from maybe same community, and if I misbehave with you, I borrow something, do not pay back, you can badmouth me, I fearing that I will pay you back, even if there is no um, court of law around. Or I may find it in my interest that, you offer me very good deal. You and I both are business persons. You offer me very good deal. If I offend you, then I will have to do business with someone else. This situation arises in a repeated game situation. And else somebody else is not going to kind of provide me the quality of goods and services you provide, or they will charge higher price. Again, I will behave responsibly with you even in the absence of court law. court of law. But these situations are not, these situations arise in some context, not in all context. The contract law works everywhere. Contract law allows two strangers to make a deal without, even if you and I, contract law allows us to enter into an agreement and fulfill terms of that agreement, even if you and I have never known each other beforehand and are never going to see each other ever again. Even then, contract law can make us behave responsibly. That's the point of contract law. It is not needed everywhere, but it is needed in many situations.